Brittany Haler is an investigative journalist for the Pittsburgh Current who has done extensive reporting on inmate deaths at Allegheny County Jail. Ms. Haler submitted right-to-know law requests to Appellee Allegheny County, requesting the autopsy or external examination and toxicology report for Daniel A. Pastorek, a prisoner at the Allegheny County Jail who had died November 26, 2020. The county's Open Records Office denied Ms. Haler's request on the basis of the autopsy records exemption to the right-to-know law, but did supply Ms. Haler with the decedent's name, cause of death, and manner of death. Ms. Haler appealed the county's response to the Pennsylvania Office of Open Records, which held that the reports Ms. Haler requested are not exempt from disclosure under the autopsy records exemption, ordering the county to provide the records responsive to the request pursuant to the Coroner's Act. The county appealed this decision, and the trial court reversed the final determination of the Office of Open Records. Ms. Haler appealed to this court, bringing us to today's argument. Ms. Haler argues that the trial court erred and misapplied the Coroner's Act to determine that appellants weren't entitled to autopsy and toxicology records. And with that, we go to today's argument.
Good afternoon, Your Honors. May it please the Court, Sasha Dudding for the appellants. And with me here today, I have attorney Paula Knudsen-Burke, as well as appellant Brittany Haler. I'd like to reserve 3 minutes of my time for rebuttal, please.
You have it.
Thank you. Access to autopsy records is critically important to appellant and journalist Brittany Haler and to members of the press and public. Autopsy records can shed light on the deaths of members of vulnerable populations, such as Daniel Pastorek, who died while in custody at the Allegheny County Jail, and whose autopsy and toxicology reports Ms. Haler requested in this case. Autopsy reports can also shed light on important public health trends like COVID or opioid overdoses, as well as the operations of taxpayer-funded coroners' offices. This information can lead to public discussion, oversight, and, as needed, reform. This case in particular shows the importance of access to autopsy records. Mr. Pastorek was homeless before his incarceration and had no next of kin able to request his autopsy report. Ms. Haler is the only one trying to find out what happened to him and whether conditions at the jail may have led to his death. Adopting the county's reading of the Coroner's Act in this case would cut off public access to autopsy records in 4 of the Commonwealth's largest counties, misreading a statute that's simply about setting fees for reports, not restricting access to them. Specifically here, the trial court erred in holding that Ms. Haler was not entitled to access autopsy reports under the right-to-know law and Section 1252B of the Coroner's Act. The right-to-know law does contain an exception for autopsy records, but importantly, the right-to-know law also has a conflicts provision, which says that when another federal or state law conflicts with the right-to-know law, the right-to-know law shall not apply. So where disclosure requirements found in the Coroner's Act conflict with those found in the right-to-know law, the Coroner's Act controls. So the Coroner's Act provides 2 ways for the public to access autopsy and toxicology reports. The first is in Section 1236B, records. Coroners in counties of the 3rd through 8th class under that statute deposit their official records with prothonotary by January 30th of each year, and there they can be accessed by members of the public. Now, Allegheny is a county of the 2nd class, so that provision is not at issue here today. But the second access method is Section 1252B, titled Fees for Reports. That provision requires counties of the 2nd through 8th class, so including Allegheny, to permit paid access to coroners' records, providing a rapid means of accessing records for those who can pay the fees.
So if this had occurred in a different county that was subject to the first provision, where it was deposited with the prothonotary, your client would have had no trouble getting that.
Well, that provides a method at the end of the year. So she could have done that in, say, a 3rd class county after January 30th of the year. But if she wanted rapid paid access in any county of the 2nd through 8th class, this is the provision 1252B through which she would do that. And we know that from the Hearst Television and Penn Jersey cases. Section 1252B, like 1236, conflicts with the right to know law, so requires county coroners and medical examiners to provide access consistent with its plain language. That means the key question here today is what exactly that language requires. So it's helpful to take a close look at the text, which reads in relevant part, "The coroner shall charge and collect a fee of $500 for an autopsy report, $100 for a toxicology report, and other fees as may be established from time to time for other reports or documents requested by non-governmental agencies in order to investigate a claim asserted under a policy of insurance or to determine liability for the death of the deceased." That last phrase about investigating insurance claims and determining liability is new to the 2018 revision of the Coroner's Act, and it's really the key language that's at issue today. But that phrase at the end about insurance and liability only applies to and modifies requests for other reports or documents requested by non-governmental agencies. It does not apply back to requests for autopsy or toxicology reports listed at the beginning of the statute. Anyone can pay $500 for an autopsy report. That has not changed. The added language at the end has no effect on those requests, which are the requests made by Ms. Haler in this case. The statute's even titled Fees for Reports, which further shows that it's just a fee-setting provision, not a new severe limitation on public access as the county claims.
Are there any provisions in the right to know law which would restrict some of the personal medical data from getting out?
So because the right to know law and the Coroner's Act conflict in this case, we do look to the Coroner's Act for what can be disclosed under this provision, but the privacy concerns the Pennsylvania Supreme Court addressed in Penn Jersey and said that while this does affect and permit public access across the board, which is important for a host of reasons, people with standing to do so can petition trial courts in specific cases to seal access to autopsy reports as needed. Trial courts have indeed done that. But overall, the legislature made the determination that public access is the overriding concern here. There are some states that choose not to permit public access to autopsy reports, but here the General Assembly chose to permit those two methods of access. So the court has to look at that legislative determination here.
So your position is that Hearst controls? The Supreme Court's decision in Hearst controls, which is what the OOR said, that there's only discretion as to the fees that are charged, but not to the right to access the records.
Yes, as to autopsy as well as toxicology reports, the language in Hearst Television is still the same. The General Assembly just raised the fees. The language at the end of the law, which is new since Hearst Television, only affects those requests for other reports, which are not at issue here in this case. So yes, when it comes to autopsy reports, medical examiners do not have discretion upon receipt of the $500 fee, which Ms. Haler said she's willing to pay. They must disclose the requested reports. The statute simply functions by setting specific fees for specific types of commonly requested records, like autopsies. And then it ends with that catch-all for other records that can be requested from time to time, which sort of accounts for the fact that, there's 67 different ways of doing things. Different coroners or medical examiners can have different types of records, and they can put in their fee schedule other records that might be used to determine liability. For example, Delaware County has something called investigator scene reports in their fee schedule, but they wouldn't be able to charge for something under the statute that's unrelated, like, for example, an employee handbook or a budget. It's just sort of determining which types of records can go in that fee schedule. But again, that all has to do with that language for other reports at the end. None of this is affecting the request for autopsy reports. This reading is entirely consistent with the General Assembly's stated intent during the 2018 code revision, which revised this law. The General Assembly said in the executive summary and section-by-section commentary to the code revision that it was simply trying to increase the fees for reports to allow coroners and medical examiners to recover more of the actual costs of their services. Used to be $100, now it's $500. It made no mention of any intent to limit access. In fact, it rejected requests to limit access. There was a proposal on the table that would have said the right to know law's autopsy exemption controlled and barred disclosure, but the General Assembly removed that from the law. Excuse me. The General Assembly also rejected an attempt to include in the law a disclosure provision that would have only allowed access in response to a subpoena or a court order. Again, it only raised the fees for the autopsy reports. This also makes common sense. I mean, the General Assembly did not want coroners and medical examiners to have to be looking at requesters' motives with every request. This is a simple, straightforward statute, easily applied by already trained coroners and medical examiners staff. Someone requests the autopsy report, pays the fee, the report is disclosed.
Well, you're seeking this under the right to know law. Why not just go to the medical examiner and request the documents from them? Because even in accordance with Hearst, you're saying you would be entitled to those documents. Our right to know law says if there's a conflict, so the right to know law says you don't get access, and it says if there's a conflict, another law will govern. So don't you go to the other law and file a deck action or mandamus against the medical examiner?
The Coroner's Act sets the substantive disclosure requirements here, but we know from Hearst Television, the Supreme Court said, quote, "The right to know law provides the procedure for accessing those records that are available for immediate release for a fee." So that's still the way these two acts are set up, and that's how it works here. The right to know law is the vehicle for requesting.
How does the right to know law provide access for these if it denies it? And see, this is a little bit different than what we've seen before. It denies the access, or sometimes it might grant access, and a different law says, no, you don't get them. Here it says access, you don't get it for autopsy reports from coroners. But the Coroner's Act is in conflict with that, so the Coroner's Act governs.
Yes, so here, and the right to know law's conflicts provision is really the operative part of the right to know law here, and that points us to the Coroner's Act and any other federal or state law that might be in conflict with the right to know law. The right to know law remains the vehicle, so a right to know request is submitted, the county or state agency would still bear the burden under the right to know law. It's sort of all within that right to know law umbrella, but what the fee might be and what is subject to disclosure, we see from the Coroner's Act itself. I'll just mention also two principles of statutory interpretation that also counsel in favor of our interpretation of the law, which we discuss in our reply brief. There's the rule of the last antecedent, which says that when there's a limiting phrase at the end of a list, so here that phrase about determining liability, that should be read as applying only to the item in the list right before it, requests for other records, and not to all the other items in the list. So it does not affect requests for autopsy records. Similarly, where there is no comma before that limiting phrase at the end of a list, we only read that phrase as applying back to the item right before it, and again, not the earlier items in the list. And that's fully consistent with the General Assembly's intent, as well as just looking at the plain language of the law. I'll add that even if this court does adopt the county's interpretation of the law, Ms. Haler has shown she is seeking to determine liability in her affidavit, which you can find at page 164 of the record, specifically paragraphs 9 and 10. She talks about her investigative journalism work and how figuring out the circumstances of Mr. Pistorik's death at the jail could help determine liability as to whether the county officials might have had to have better medical conditions.
Counsel, let's explore that for a moment. So you're saying her goal is to determine liability, but she's not going to impose a dollar amount of damages or criminal sanctions for that. She's going to determine rather responsibility, isn't she?
Yes, I see my time has elapsed, but I'll just answer quickly. We argue the lower court erred in adopting an overly narrow definition of the word liability, ignoring its ordinary meaning and plain usage.
You're arguing for a broader.
Yes, we do argue that even under the lower court's definition, she is seeking to determine liability because many lawsuits have arisen out of reporting on autopsy reports, but liability also encompasses reporting that can lead the public to be informed and hold state officials accountable through their actions, whether that's through the courts, policy or personnel changes, or budgetary changes. Thank you.
Thank you very much.
Thank you. May it please the court. My name is Margaret Shields. I'm an assistant county solicitor for Allegheny County. I'm here on behalf of the county and specifically the Office of the Medical Examiner. And we're here because we believe that the medical examiner is not required by any law to provide the autopsy report to Ms. Haler that she requested.
How do you get around Hearst?
Well, that's a really good question. Hearst was decided before 2018, before the language about determining liability for a death was added to the fees provision. But that's not the most important distinction. The most important distinction between this case and Hearst is that Hearst involved a coroner from, I believe it was Cumberland County, who was required by the Coroner's Act to deposit all of his official papers and records.
Is there any discussion in Hearst of what kind of a county it was? I may have missed it, but I didn't see any.
So I'm assuming that it would have had to have, because Hearst,
I didn't see it.
well, Hearst discussed Penn Jersey, which I know discussed that provision. If that discussion isn't in Hearst, it could be because access to an autopsy report may not have even been raised in that litigation. I think it was clear from the beginning that the Cumberland County coroner's autopsy reports, because of Penn Jersey, had to be deposited with the prothonotary toward the end of the year. And so Hearst was really a case about timing. It was a case about when someone could obtain an autopsy report from the Cumberland County coroner. The outcome of Hearst essentially was that the right to know law was found to be an appropriate vehicle for someone who was already going to get reports eventually to get them sooner. So Hearst really built on Penn Jersey, but the difference between the two cases was that Hearst discussed the right to know law. I get around Hearst, and our position is that because Hearst and Penn Jersey were discussing a coroner whose reports had to become public eventually, access to reports wasn't really an issue in those cases. In Penn Jersey, they had to decide whether an autopsy report was part of the bundle of things that would become public eventually, and they decided that it was. In Hearst, it was already clear that an autopsy report would have to become public eventually, so they had to determine whether you could use the right to know law to go ahead and request a report instead of what Judge McCullough suggested, which was, requesting them directly from the coroner and then filing a mandamus action if you don't get them. So it's
If we accept the appellant's interpretation of the amendments to the new Coroner's Act, then we're not even talking about Hearst. Hearst doesn't even come into play because we're looking at a totally fresh field.
right, and
So
that's
can you respond to the appellant's argument, how they interpret the new Coroner's Act? Because I think that's material.
I will, and I agree with you that it's material, and I agree with you that Hearst, in our interpretation, that neither Hearst nor the right to know law actually need to come into this analysis at all. So the key provision here is that 1252B in the Coroner's Act, which was added in 2018, a non-governmental agency seeking reports to determine liability for a death. And in my brief, I explain that the word liability doesn't mean social accountability. It doesn't mean it doesn't implicate the public's right to know. It doesn't implicate public opinion. It doesn't really even implicate.
So you're accepting responsibility is the right word that the appellant's seeking here, where the county is saying it's something higher than responsibility. Liability is
Right.
criminal liability, civil liability, not whodunit.
That's exactly right. And I think that the legislature, when they drafted the provision, that they expressed their agreement with that interpretation when they put the word legal. Never mind. The word legal comes from Black's law definition or dictionary definition. When I was writing my brief and I looked to the definition of liability, everywhere that responsibility, accountability is mentioned in the dictionary, the word legal is before it there. So what I think that the General Assembly clearly intended was to use the word liability in its legal definition. And I think that
But we still have the argument from the appellants that clause
Right.
doesn't apply to the autopsy reports. And I'm struggling with that. Tell me why you think it does apply to the
I think
autopsy
that
reports.
I think that the phrase to determine liability for a death applies equally to everything in the list. I don't think it makes any sense There's no reason to apply it only to that last phrase, other reports. It can be applied just as reasonably to every single thing in the list. I read a lot of case law about the last antecedent rule. I think that from your own case law in our Supreme Court, it's pretty clear that that's not a hard and fast rule. It's merely an aid in determining legislative intent.
Well, but they made a change. Before they added that phrase, people would pay the charge and be able to get it. They didn't have to show that it was used to investigate a claim. But when you leave it open for other reports or documents, that's unlimited in terms of what they might have. And so in order to try to place some boundaries on what would be available, to tie it to some other investigation seems appropriate. But why would they, without putting it in the notes or without making it part of the, giving some indication, why would they add that requirement on top of to limit access to documents that previously had been available?
Well, the documents from Allegheny County's medical examiner's office were never previously available. So Allegheny County has never had to deposit its documents with anyone at the end of the year.
But upon paying a fee, could people get them?
Upon paying a fee, I believe it was either 2018 or 2005 when Allegheny County was brought under the Coroner's Act and the fees provision specifically. From that point on, we were able to charge fees for certain reports, but our other items that were not included in that provision were never able to be made public, or required, I should say, to be made public.
I guess the question, though, is did you provide them upon payment of a fee?
Did I in what case? Or did we in what case?
Before,
I mean, would we?
Yeah, before 2018.
Well, the medical examiner has always had a dissemination policy that they do apply very consistently. They don't charge fees in every case. For example, family members, next of kin, can always receive free reports. Obviously, so can law enforcement. They look at every request independently, and they do seek legal review from my office in most cases. And if it's determined that the person who has requested the report is legally able to obtain it, including under this provision that says to determine liability for a death, then yes, they do charge the fee and release reports. And going back to the last antecedent rule, when the modifying phrase at issue is applicable as much to the first words as to the last, then the natural construction of language demands that the modifying phrase be read as applicable to all. That's a quote from a Commonwealth court case, Summit Township Industrial Development versus County of Erie. I think that this court is aware that something like the last antecedent rule has been applied or not applied in many different cases. And this case about, access to reports in the second largest county in the state, I think it's too important to turn on the placement of a comma, particularly when the General Assembly has specifically excluded Allegheny County and Philadelphia County also from having to make all of their medical examiner reports public. The fact that with every step of the way of amending the county code, amending the Coroner's Act, Allegheny County and Philadelphia County have never been ordered to make all of their reports public. I think that
maybe that was just because there were so many reports. How do we know why they didn't mandate that? There are a lot more reports, presumably, on either end of the state. That doesn't mean by implication that if someone under 1252 pays the fee, they're not entitled to a copy of it just because they don't have to file all of them with the Prothonotary at year's end.
Well, the Office of Open Records and appellants, they are basing their case in large part, in fact, in full, when it comes to the Office of Open Records, on the Hearst television decision, which was purely based on the interplay between the different sections of the Coroner's Act and the Right to Know law. In this case, the laws that Allegheny County is required to follow are that when someone requests a certain type of report, autopsy and toxicology in this case, for a certain statutorily prescribed purpose, we must give them the reports in exchange for certain fees. However, our position is that the modifying language that was added in 2018 does allow the county to draw a line between the type of requester who can actually effectuate some sort of an official decision involving legal liability and someone who just wants to publicize an autopsy report. And I'm sure this court is aware autopsy reports are very graphic, they're very private. The medical examiner does have a very carefully thought through dissemination policy that it does apply, but journalists have never been on the list of recipients, and I, through researching this
Yet
case, have
journalists could easily access them at the end of the year in all the other counties that are required to file.
That's correct.
Yeah, so, I mean, they're just as graphic, so.
So what says
And
Allegheny?
it somehow seems patently unfair that certain parts of the state can get these records and certain parts can't. Under the right to know law. I mean, it feels like an absurd result.
I think that as well. I think that the right to know law explicitly exempted autopsy reports from disclosure in exemption number 708B20. However, our Supreme Court, in their wisdom, did decide that the provision in the Coroner's Act about depositing reports at the end of the year conflicted with the right to know law in the Penn Jersey case. In the Hearst television case. And so, that's the precedent that we have to apply. And in this case, however, it just doesn't apply because of the particular class of county that we're dealing with. And I do want to use a little bit of time to make the court aware that the Allegheny County Office of the Medical Examiner is a state-of-the-art office. The medical examiner is an appointed position. He must be a forensic pathologist with 5 years of experience. The office has 5, I believe, certified forensic pathologists and dozens of investigators. They have a state-of-the-art crime lab. They have an environmental lab. There are a lot of reports that are generated here, and there's a lot of work that is done in this county that, simply isn't done at that scale in the other counties.
Which is why they probably don't require you to file them with the pathonetary at the end of each year. But I think Judge Seisler's point is well taken. You don't have access to everyone else's autopsy reports all across the state. And then when you get to Philadelphia and Allegheny County, it's all the discretion of the coroner, which is, I think, what I hear you saying.
That's what the law says.
Well, that's what you're saying 1252 says.
That's correct.
That's your interpretation.
That is my interpretation of 1252, and there really isn't, there hasn't been a case yet where a court has interpreted how 1252 acts upon a county of the second class, which is why I think Hearst television is completely irrelevant, and it's why I think the right to know law is irrelevant. I think we are solidly able to rely on that exemption 708B20 as far as right to know requests. I think that in this case, it should not have been handled the way it was under the right to know law. I think the Office of Open Records was completely wrong. What we're asking is that you affirm the trial court, specifically the trial court's finding that to allow someone whose only goal is to publicize an autopsy report to obtain one, it really renders the new language from 2018 completely meaningless.
Well, I don't think that's what the appellant is seeking to do here. She's not seeking merely to publicize it. She's seeking to find responsibility for this man's death.
She's seeking to shed light. That's the phrase that comes up over and over in this case. She's seeking to shed light on what she thinks may have happened. And
what's the purpose of shedding that light? Sunlight's the best disinfectant.
To determine liability. Right.
Sunlight can't determine liability. Only the legal process can do that. If she wrote something.
Sometimes the legal process needs a little bit of prodding, if you will.
I'm not going to concede that prodding is what the General Assembly intends. I think in this case it's clear that autopsy reports from Allegheny and Philadelphia County are not accessible under the right to know law. or by
If
a
they
journalist.
were, if we disagreed with you, would there be some sort of redaction that could be placed in these reports based on the privacy interests that the courts have found in certain aspects of records?
I have a feeling that my client would say no to that, but I am not aware.
Okay, thank you.
Thank you very much.
It would be hard to know what to redact if you're trying to determine liability.
Well, we would argue that redactions would not be appropriate on an across-the-board level. The Coroner's Act does not provide for any redactions, and that's the act that disclosure would be based on. But again, people withstanding to do so can petition for sealing or redaction, and courts can make that determination on an as-needed basis, which has occurred. Courts can use their inherent authority to do that. But overall, what the county is trying to do here is rewrite Section 1252B to do far more than the General Assembly said. This is simply a fee provision permitting paid, rapid access to autopsy reports. It is not a new severe limitation on public access to autopsy reports in 4 of the state's largest counties. That reading goes against not only the plain language of the law, but also the General Assembly's intent, which does come into play when courts look at the last antecedent rule. It applies unless there's contrary evidence of the General Assembly's intent. We fully agree that this is a highly important case. Access to autopsy records is critically important to shed light on the operations of government offices, as well as coroners and medical examiners' operations, and a host of other issues. For example, here in Pennsylvania, investigative reporter Pete Shellum used reporting in part based on autopsy records to find out that the wrong people had been convicted of murders, leading to exoneration of those individuals and proceedings against new individuals. But again, the General Assembly firmly rejected all requests to limit access to autopsy reports when it was looking at this code revision. I'll also note that the second-class county code in place before 2018 had a paid access provision that applied to Allegheny as well as second-class A counties. That was in section 4235.1C. So paid access has always been the norm here, and the General Assembly never intended to or wrote into law a provision changing that. This court should not permit the county to use this straightforward fees for report statute to limit public access to autopsy reports and toxicology reports in a way the General Assembly never intended.
Ms. Dunning, I have a question just factually here. The decedent here, who's the object of these reports, Mr. Pastoric.
Yes,
I think I read somewhere that he died without having any family. Is that
that's
correct?
correct.
So would he have any surviving privacy rights in this?
That's an interesting question, Your Honor. The OOR has looked at this and found that privacy rights do not survive after death and are not able to be raised by the relatives.
Nothing in our case law, though?
Nothing so far, no.
This would be a case of first impression.
That's correct.
Since he has no family, who would be the appropriate entity to vindicate those privacy rights under a PSCA analysis?
Well, what we think is essential here is that the Supreme Court has twice looked at requests for autopsy reports in Penn Jersey and Hearst Television, and twice found that the disclosure of those does not violate individuals' privacy rights. In the past, when it comes to decedents' autopsy reports being requested to be sealed, DAs and law enforcement officials have made those requests. But again, the essential thing to remember here is that the Supreme Court in Hearst Television, which does continue to apply fully here, has held that access to autopsy reports is what the General Assembly intended to permit, is what it wrote into law, and that remains true today. If the court has no further questions, I would simply ask the court to reverse the decision below and order the county to disclose the requested autopsy and toxicology reports upon receipt of the fees from Ms. Haler, consistent with Section 1252B of the Coroner's Act and the right to know law. Thank you.
Thank you very much. Appreciate the arguments. Very well presented.